Doctor, is it your opinion that the treatment that you rendered to my client on February 1st was appropriate and within the standard of care? The defense attorney yells out, "Objection, don't answer that." Can the defense attorney tell his client not to answer that question? And two, do I have the ability to ask this doctor, the doctor whom you have sued, a medical opinion question as if he were a medical expert? Would you like to know the answer? Come join me for a walk around the lake as I share with you the answer to that question. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney. All right, you brought a lawsuit against the doctor and hospital staff claiming that they were careless and caused you significant harm and injury. During the course of your lawsuit, I have an opportunity to go ahead and question the various doctors whom you have sued in a process known as a deposition. That's also a question and answer session which is under oath and typically takes place in the doctor's attorney's office. Nowadays, it takes place on a Zoom video call. All right, lawyers also call this an examination before trial. And you should know that the answers that the doctor gives to my questions represents his sworn testimony and carries the same exact weight as if he is testifying in court, at trial, in front of a judge, and in front of a jury. All right, so now, during the course of questioning the doctor whom you have sued, I turn around and ask him a question. Doctor, do you have an opinion as to whether the treatment you provided to my client was appropriate and within the standard of care? And the defense attorney yells out, "Objection! Don't answer that, doctor!" Can the attorney turn to his client and say, "Don't answer that question"? In New York, there are very few instances where he is permitted to do that. Number one, if my question is palpably improper, off the wall improper, such as if I ask him, "Hey doctor, how many times do you beat your wife each night?" That would be a palpably improper question, okay? If I ask the doctor what he talked to his attorney about, that would be improper, and that would be trying to delve into private, privileged conversations with his attorney. And I can't do that either. Okay, what about opinion questions? Well, I want to share with you that in New York, I am permitted to treat the doctor as if he is a medical expert. Now, you might be asking yourself, okay, if I treat him as a medical expert, why am I permitted to ask him opinion questions? And do I have to use open-ended questions, allowing the doctor to explain his answers? The answer is, I am permitted to go ahead and ask the doctor opinion questions because the law considers this guy to be a medical expert, regardless of whether he's competent or not, regardless of whether he committed malpractice or not. The fact is, he graduated college, he went to medical school, he graduated, he went through his residency training, and he graduated, and now he's in practice. And so, because he's licensed and in all likelihood board certified, the law technically considers him to be an expert. That gives me the opportunity to ask the doctor leading questions. Now, what's a leading question? By making a statement and asking the doctor if he agrees or disagrees. Doctor, isn't it true that on February 1st, my client came to you with the following complaints? Yes. That's a leading question. I am making a statement and simply getting the doctor to agree or disagree. Doctor, isn't it true as a result of the patient complaining of a breast lump, it was necessary and critical for you to do a thorough and detailed examination of the patient? Yes. And you would agree that when doing a breast examination, it's important for you to do the following things, correct? And he's got to say yes. So, what am I doing? I am asking leading questions. I'm not giving the doctor an opportunity to explain anything yet. But now you might also be thinking, wait a second, this deposition, this is not trial. This is part of the discovery process. Don't I also want to ask him questions about his understanding and have him explain? The answer is yes, I do. There are many instances where I will make a statement to the doctor and he will disagree. I might say to the doctor, "Doctor, isn't it true that on February 1st my client made the following complaint?" And he might turn around and say, "No, that's not true." In which case I will say, "Doctor, tell me what you mean by that. Explain. What complaints did my client make on that visit?" And now I'll follow through and ask follow-up questions based upon the doctor's responses. When I question a doctor, it is critically important for me to establish and understand why the doctor did what he did. I need to establish what the baseline standard of care was for a patient with a similar condition to my client's. I need to understand whether the doctor has a good knowledge and understanding of the medicine as to what represents good and accepted medical practice. And now when we go through my client's medical records and establish what was done based upon my client's complaints and her clinical presentation, I need to know whether the doctor feels that the treatment that was rendered or about to be rendered represented good and accepted medical practice. Now, what do you think is going to happen when I turn around and ask the doctor, Doctor, do you have an opinion as to whether the treatment you rendered to my client was appropriate and within the standard of care? What do you think he's going to say? He's going to say, of course it was. I did nothing wrong. And then he's going to turn around and say, listen, even if I did something wrong, whatever I did didn't cause or contribute to your client's injuries. And then he'll turn around and say, you know what? If I did something wrong and I did cause your client harm, her injuries really aren't as bad as you claim them to be. Those are the typical, what we call affirmative defenses that arise in these medical malpractice cases. So now let's get back to the question I raised in the title of this video. Am I permitted to ask the doctor opinion questions? The answer is yes, I am. I am permitted to ask this doctor because he is considered a medical expert, which means I am permitted and will always ask the doctor questions about whether the treatment that he rendered was within the standard of care. In response to that, they will often turn around and say, not only was it rendered within the standard of care, but it exceeded the standard of care. So what do I do in that instance? You know what I'll do? If the doctor disagrees with my statement, asking him an opinion question, I'll turn around and say, Doctor, tell me why. Explain to me why you disagree with that. And now the doctor will have to articulate a reason why he disagrees with what I am proposing. Now, there are many instances where our version of the facts are different than the doctor's version of the facts. And you might be thinking, wait a second, I don't understand. There's one set of medical records. You have a patient who came in complaining of the following things, and now the doctor has his notes from that visit, and now he's establishing based upon his notes what the patient said and what he did. How could there be any factual differences? Well, first of all, the medical records might not be accurate. So now I'm going to ask the doctor a hypothetical question. Doctor, I want you to assume the following to be true. I want you to assume that on February 1st, my client came into your office with a complaint of a breast lump at the 12 o'clock position on her left breast. Assuming that fact to be true, would you agree that failing to do a detailed and thorough physical examination of her left breast would be a departure from the standard of care? He has to say yes. But many times he'll turn around and say, I disagree with those facts. Doctor, I understand you disagree with those facts. However, for the purposes of my question, my client has testified, and I want you to assume my client has testified that she complained to you on this particular visit of a breast lump in the 12 o'clock position on her left breast. And as a result of that, you failed to do a physical examination of that breast. If that were to be true, would you agree that failing to do a physical examination in light of those complaints, that would be a clear departure from the standard of care, correct? Now, his attorney's going to yell out, objection! Don't answer that. Can the defense attorney do that? The defense attorney can do the first part. He can yell out objection, but he can't direct the doctor not to answer. That would be totally improper. Why? Because my question that I asked, this hypothetical opinion question, based upon the facts of what my client testified, is totally appropriate. So in that instance, the doctor has to let his client answer the question. He can raise a stink as much as he wants, but the doctor still has to answer the question. So, in this particular scenario, every time I asked the doctor a question, the defense attorney yelled out objection. Every now and then he'd tell the doctor not to answer, and then we'd have a brief legal argument about why he couldn't do that. The one thing that the attorney did do correctly was, in one or two instances, I asked the question, I said, Doctor, do you have an opinion as to whether or not the treatment rendered here or rendered by another physician who was also on your team was in accordance with good and accepted medical care? In that instance, the defense attorney correctly pointed out that I didn't ask the question correctly, the way I should have. And in that instance, I give him credit. He was right. He pointed that out. So what did I do? I corrected my question. I said, okay, doctor, do you have an opinion with a reasonable degree of medical certainty as to whether X, Y, and Z? Now, many times when I ask the question that way, the doctor will turn around and say, no, I don't have an opinion, which means I can't even get to the root opinion about why things were done or why he thinks they should or should not have been done. In that instance, it basically cuts off any further inquiry about whether or not he has an opinion. Now, let me share with you why that answer can sometimes be helpful at the time of trial. Let's say I asked the doctor 5 or 10 opinion questions, and in each of those instances, the doctor claims not to have any opinion whatsoever. Now, a year later, your case comes up for trial, and during the course of trial, the defense lawyer asks the doctor opinion questions. Doctor, what's your opinion as to why this patient suffered all these injuries? And now the doctor elaborates greatly and explains in depth why this patient has all of these injuries, and they are unrelated to any of the care and treatment he rendered. Now, what has the doctor just done in that instance? He's now contradicted what just occurred. He's contradicted the information I established during his deposition a year earlier. And you better believe the doctor is now going to be cross-examined vigorously about the discrepancies between the testimony he gave during his deposition a year earlier and now totally different at trial. And that can be very useful to discredit the doctor. Why? Because clearly his memory was better a year earlier. And clearly the only reason he's now trying to establish and slough off responsibility at trial is to somehow deflect any liability, deflect any problems about causing this patient injury and harm. But a year earlier, when he was asked these same questions, I have no opinion. I don't have an opinion. I don't have an opinion. Now all of a sudden at trial, he develops an opinion? Could it be because he consulted with his attorney and this was the strategy they were going to employ? Why do I share this quick information with you? I share it with you just to open your eyes and help you understand how these types of medical malpractice cases work in the state of New York. You know, I realize you're likely watching this because you wanted to see the beautiful scenery. No, I realize you're watching this because you likely have questions or concerns about your own matter. Well, if your matter did happen in New York, and you are thinking about bringing a lawsuit, but haven't done so yet because you still have questions that need to be answered, what I invite you to do is pick up the phone and call me. You know, I answer questions like yours every single day, and I'd love to chat with you. You can reach me at 516-487-8207, or by email at Gerry, Gerry, at oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a wonderful day.